that maybe we want to offer rewrites of some of the definitions like disability or qualified individual with a disability. As we talked through it last week, it sounded to us like folks didn't necessarily think that we needed a whole cloth rewrite of those as much as maybe integrating substantively what's in the ADA. And I know Andrew has offered some clarifying rewrites of that we'll talk about today, some suggestions on some of the specific terms. But what we took away was we're probably not ready right now to recommend any specific rewrite of those definitions, and that probably the definitions we may want to, and it's a big may, but our current thinking is there may be some suggested new definitions on some of what I'll call the downstream terms that are in the ADA that we may want to integrate here around some things like communications or certain accommodations. Separately, we have the big meaty topics for us to address, like caps and modernizing the dollars from 1991 and timelines for filing claims. But I want to, for today, talk about it in two separate frameworks or chunks of this, one being the definitions and then the other being the big provisions that we're going to need to have some meaty conversations on. So let me first just open it up to the group. Are we understanding right where this group is in terms of the definitions, or does anybody want to suggest that there are specific definitions that we can in the next 7 days get to consensus on recommending versus saying we're going to look at these and prioritize them early in 2024? And I am going to call out our first two lawyers in just a minute to get the conversation started, because this is really nuanced. And my only hesitation in trying to get to now is I want to make sure that the full group is comfortable. But Andrew or Ian, what is your sense of where we are in being able to share out that we are working on these items versus offer specific recommendations on any definitions?
Barrett, do you want Andrew to go first or me to go first? I defer to Andrew since he actually put together some definitions. Sorry, this is Ian, by the way.
Yeah, no, thank you, Ian. And Andrew, I'll invite you. And I so appreciate all the work that you've put into this for years, frankly, but certainly with this subcommittee.
Yeah, absolutely. And this is Andrew, by the way. I was staying quiet because I had, in fact, put together those definitions. So, personally, I'm very comfortable with them, and, would be happy to make those as recommendations, at this stage. I mean, I think, again, as I said in that email, these definitions are largely lifted verbatim for the most part, with one substantive change that I called out in that email. But lifted verbatim from the ADA definition. So, to the extent that we're trying to incorporate that ADA definition into state law, I'm perfectly comfortable moving forward with what I proposed, but that probably surprises no one.
No, I appreciate the candor. And to be very clear, we are not coming at this saying we should not. We're trying to make sure that this whole group can feel comfortable on this timeline. I would probably be saying absolutely if we had 30 days. What I want to do is make sure that this group, and I'll ask the whole group, and I will put people on the spot, whether you've had the opportunity to take a look at that draft definition Andrew offered. And then, Andrew, I may ask you to talk us through it, because to your point, to the non-lawyer, it may look very complicated. As I reviewed the parallel statutes, it's very minor changes. But let me just first ask, have folks had a chance to look at that draft definition that was sent around that Andrew shared?
I have not, sorry.
No, it's okay. What I'm going to do is drop it in the chat. And Andrew, would you be comfortable just talking through in a very just plain, and it looks like Carrie, can you drop that link in? I'm not able to share it. But Andrew, could you, as we're doing that, could you talk through your thinking and really specifically articulate where this is different from both what is currently in CADA and the alterations that you're suggesting for clarity versus what's in the ADA?
Okay, sure. So I guess just to start off with, the definitions that are in COTA essentially refer to the ADA definition. Um, there is some, some strangeness around individual with a disability, that phrase being defined in COTA and not being defined in the ADA, despite the COTA attempting to incorporate that definition, which is part of why I think we got to talking about this in the first place. But the ADA definition of COTA is essentially what's set forth here in this definition of disability. The one change that I made, I'm trying to locate it right now. It's in the regarded as section. And I inserted the word actual in one spot. Okay, there we go. It's, what is this? 7C2. So for the purposes of the subparagraph. Anyway, I'll get back to that so we're not getting too far in the weeds before we've actually had the forest view. So disability under the ADA means one of three things. It can mean an actual impairment, you actually have the disability that you're claiming. It can be having a record of having a disability. So, for example, someone gets a hold of your medical records as part of a medical review, and they see that you've been diagnosed with something, and they treat you differently on that basis. That's also another covered definition. And then finally being regarded as someone. It's kind of similar to the previous one, but it's where, someone looks at you and sees maybe something that they perceive as a disability and treats you differently on the basis of that. So, a disability is a physical or mental impairment that substantially limits one or more major life activities. So within that phrase, there's a lot to unpack. So, of course, the first is what constitutes an impairment. The definitions kind of go into what constitutes a disability, some of the interpretive guidance, and then another is what is substantially limits versus other potential limits. Maybe it's not so substantial, for example. And of course, what is a major life activity? So what the ADA does, and this was done with the ADA Amendments Act in 2009, 2010, something like that, was really expanded the definition of disability between the Amendments Act and the interpretive guidance from the Department of Justice, and I believe from the EEOC as well. It's made it very clear that, the focus shouldn't necessarily be on whether someone has a disability, it should be on what happened. And meeting that definition of disability should be fairly easy. They've set forth, what constitutes, for example, a major bodily function, what constitutes a substantial limitation. If you look at E, as Ian had mentioned before, you don't, you no longer consider ameliorative effects of things like medication or, assistive devices. So that's, that's kind of the forest level view. Getting into that specific of the one word that I added, I'll read the paragraph. Paragraph 7C shall not apply to actual impairments that are transitory and minor. A transitory and minor impairment is with an actual or expected duration of 6 months or less. So essentially, you break an ankle, you may be in a wheelchair for, 5 months. That doesn't constitute a disability, even though you are, using a wheelchair. I added the word actual to make it clear that, we're actually talking about a real impairment. I'm in no way wedded to that addition, but that is the one and only change that I made. The rest of this is literally lifted verbatim from the ADA.
So what I'm going to ask is I want to have some conversation on this. I also want to be fair to everybody, and I'm going to ask everybody to also read this offline when you've had the chance and send us some thoughts. But based on what Andrew has walked through, what questions? Lauren, did I see your hand come up? Please jump in.
Yeah, Andrew, thank you for working on this. In our last discussion, I got the impression that a number of you were satisfied with the ADA definition, and I'm just curious, what does that word actually do, or why add it, Andrew? Could you walk me through that? Thank you. This is Lauren speaking, by the way.
Yeah, absolutely. So as I was reading through the definition, it just seemed like it would frankly clarify what we're talking about. If you have an actual impairment that is expected to last in duration less than, that amount of time, it doesn't constitute a disability. I'll be honest with you, as we sit here today and we're reading over it, I'm not so sure that it's a necessary change. I'm not sure it adds a whole lot. As I was putting it together, it made sense and seemed to flow a little more cleanly. But again, as I sit here today, I'm having trouble, I guess, getting back into that same frame of mind and seeing the import of it. So, frankly, if we were to strike that addition, I would be perfectly fine with that. And the rest of this again is verbatim from the ADA.
Thank you.
What other questions or reactions do folks have, or where is your current thinking on offering this as a recommendation? And to be clear, I believe the recommendation would be that we change or add the definition in CADA to be this definition as drafted, which, as Andrew has said, parallels the ADA. I think Andrew and Ian, I'd like to ask you as lawyers practicing on different aspects of this, why would we want this? And I'm asking this, and I know you've addressed it to some, but I want to be very clear for the group discussion. Why would we want to actually incorporate and memorialize this into Colorado revised statutes as opposed to the state's current approach of referencing the ADA?
All right, so this is Andrew again. One of the reasons I think that's really important is because federal law can always change. By incorporating this directly into state law, it's making it clear that this is the Colorado definition. To the extent it parallels and mirrors the federal definition, that's great. But if that federal definition changes, for example, we may or may not want to follow along with that change. We've seen a lot of changes, mostly in case law, but a lot of changes to some of the standards that we've all grown accustomed to over the years. Here over, I'm going to say the past 3 or 4 years, based on court decisions that have kind of undercut or simply overturned longstanding precedent. So we want to be cautious that we're not, teetering on the brink of losing these definitions based on, a few judges or justices of, whatever court making certain decisions. So, incorporating that directly into state law would protect us from that being the case.
Thank you, Andrew. I really want to push the group. Ian, please.
Thanks, Barrick. I want to jump in on that. This is Ian Kalmanowitz. In addition to everything that Andrew just said, which I think is completely right and is exactly why we should be doing this. The other thing to consider, from my perspective, is that we have our state law and our state courts have been recognizing that when our laws go beyond the protections that are offered in federal law, that we need to apply those greater protections. And, we have had recent state Supreme Court decisions on that in various areas with respect to things like wages, for example, or, other, violations of state constitutional rights. If our state constitution provides for greater protection for free speech than the First Amendment of the U.S. Constitution, our state courts have said we don't default to federal law for interpreting our greater protections under state law. And so while these definitions may be the same, if other parts of what we're going to do are intended to provide greater protections for individuals with disabilities, by not just having a statement that says disability means what it means under federal law, our state courts will be given guidance that they need to provide that greater degree of protection rather than just simply look to what federal courts have said. And so I think that's another added way of ensuring against sort of any kind of backsliding that might happen if federal law were to change, or if bad judicial decision, I say bad, from, my own subjective view. If judicial decisions that are less protective of the rights of individuals with disabilities come down, we don't have to worry about that then infecting our state law and resulting in lesser protections for the people that we're trying to provide greater protections for.
Very important points. Andrew, additional thoughts?
Yeah, one more point, and I absolutely agree with everything Ian just said there as well. Kind of from a structural thing as well, we'd like to make CAUTA, kind of a paradigm for other states, perhaps. We want to make CAUTA as strong as we possibly can. So by having these definitions directly within the state law, rather than referring to, this section for, federal law for something else, another section of state law for this other part, if we can just put it all in CAUTA, the law is going to be all the better for it.
Understood. And I want to invite the group. We're going to do a few things. One, I want to keep focused right now on definition of disability, and then separately we'll go through this process on qualified individual with a disability. But my process is I want to check for questions, then I want to check for comfort with this. Along the way, I want to again clarify with folks that what is being put in front does not substantively change the law as it is now, with the exception of, as Andrew has suggested and Ian highlighted the benefits of, bringing that referenced federal definition into state law. Do members of the subcommittee have questions about the draft proffered and what, if any, implications it has for Colorado law for individuals who may seek protection or for those who may be on other sides of it? Okay, I'm not seeing questions. I don't want to push too hard, but I am going to now ask, before I take any kind of vote on whether we want to, can I see a show of hands, either real time or using the emoticon things? Does anybody have substantive concerns about us recommending this definition be the adjustments be made in the law? I'm not seeing any. I'm going to come back in a few minutes to actually ask for a vote. But before I do, Andrew, I'd like to go on to qualified individual with a disability, which is a shorter one, and I believe really does just pull straight. But I'm going to ask you to walk us through what you've proposed here.
Yeah, absolutely. Thank you, Barrick. This is Andrew again. With respect to qualified individual with disabilities, we spoke about, I want to say last meeting, there's really only two areas where qualified comes into play. The first would be, as I gave the example, you're not qualified to participate in a jail education program unless you're actually someone who's being held in that jail or prison. The other is with respect to employment. So what I did is I pulled those definitions directly from the employment section and the public entity section, which is, again, the only spot that qualified appears in the federal law, and copied those, again, verbatim into state law. The only changes that I made are kind of some introductory language. So, with respect to that sort of thing, but nothing necessarily substantive.
Thank you, Andrew. Do any members have questions about either the language or the implications for our work, for CAUTA, and for other factors in Colorado of incorporating this, repealing and replacing with the language that has been proposed?
Yeah, this is Cindy. I just have a question.
Please.
I'm not exactly sure how to ask this without getting too confused, but under the qualified individual, there's a reference to repealed and a quote around that. Do you know what I'm talking about? Because I get more different information from the screen reader, but it talks about right under the qualified individual. It starts out with repealed, and then there's all these numbers after that. Do you see what I'm talking about?
I do. And Andrew, I'll let you make sure that I'm explaining this correctly, but I believe we're referring to repealing specific provisions of Colorado revised statutes. And one of those is the quoted definition, qualified individual with a disability, and we're defining it. Andrew, am I reading that correctly for folks?
I think so. I mean, essentially what we're saying is we're going to repeal the existing definition of qualified individual with a disability and replace it with this. That's just kind of the language that I've seen bill drafters use over the years.
Okay, I'm sorry, because I didn't know if we were looking at a different repealing something other than what we're currently working on. So appreciate that. That was my only point of confusion. Thank you.
Absolutely.
Our drafters are always sure to make it very confusing for everybody
Oh,
who
I
is not a
know.
lawyer or drafter.
What happened to plain language? No.
We're going to get to a lot of that next year. Before I want to first check if we've got more questions about this particular one, the qualified individual with a disability, and the proposal to repeal the current definition and replace it with this clarified definition that Andrew has offered. Ian, please.
Yeah, Ian Calmanowitz, thanks, Merrick. I have a comment about it more than a question. And while it is directly from the ADA, I would propose some alterations or wordsmithing of the language about essential functions of, particularly the clause, consideration shall be given to the employer's judgment as to what functions of a job are essential. And then the following clause, comma, and if an employer has prepared a written description before advertising or interviewing applicants for the job. And I raise this because what we have seen over the years are scenarios where, I mean, the simplest one I can use is a lifting restriction, where we will have somebody who works in a job that the employer says you must be able to lift 100 pounds to be able to do this job. Yet for 20 years, the employee has never had to lift anything that weighs more than 5 pounds until that individual suffers some sort of debilitating, musculoskeletal injury, a spine injury or a knee injury, shoulder injury, and now has a lifting restriction. You're not able to lift more than 50 pounds. The employer then says, well, we don't have to accommodate you because the essential function of the job is to be able to lift 100 pounds. What I don't want to say that this is something that should just be taken away from, the employer's considerations of what functions are essential. But I think a consideration of the actual functions of the job when we're dealing with individuals who have been employed in the job, have done the job, and then need an accommodation are now being told that no, there is an essential function of the job that you've never had to perform. That would be the area that I would suggest that we work on this definition before actually proposing it as something to be, formally enacted by the legislature.
Got it. And Andrew, before I ask you to respond, I want to go to the full group and check for kind of understanding and clarification. Are folks following why Ian is suggesting some modifications and what the implications of that would be, or does anybody want to ask any questions about that? Cindy?
Cindy, I'm definitely following, and I'm in complete agreement because I actually worked for an employer that absolutely used that whole ability to define the essential functions and put in every single job description. Essentially, everybody from the secretary to the director had to be able to crawl under a desk and you name it, just a whole list of things because they didn't want to hire anyone who had a disability. So I agree with you.
I'm going to leave it open to the group for questions, but Andrew, I'd like you to respond. Your thoughts on the situations that Ian is looking to mitigate against, and his suggestion of some working on this language to address that.
Thank you. This is Andrew. I would wholly support those efforts. I agree with Ian entirely, and I too have seen, cases at least. I don't practice in the employment area, but I read some employment cases where it's quite honestly somewhat disgusting, the degree of deference that is granted to employers to decide what can and can't be an essential function of the job. So I would fully support that.
Tom?
A question, are we working under the assumption that the essential functions were not defined well at the beginning, or were they defined well and true to be used and they need accommodation?
Barrett, can I respond to that?
Please.
Okay, thanks, Tom. This is Ian Kalmanowitz. What I would like to see is that if the essential functions are defined well at the outset, that would be one of the factors for consideration in determining that those are the essential functions. But I also think that an actual factual inquiry into what functions are necessarily performed by the employee is also part of that inquiry, and that one doesn't outweigh the other. So to kind of use Cindy's example of, an employer that says every employee has to be able to crawl under a desk, if that's listed as an essential function in the job description at the time the individual is hired, that would be one factor for consideration. But also for consideration would be, has that individual ever had to crawl under a desk? One of the areas where I've seen this come up in the context in terms of this specific issue and your question is employees in prisons. So if you work in a prison, regardless of your role, you are required, the State Department of Corrections requires you to complete a pressure point control tactics class so that you will be able to defend yourself in the event of, an inmate attack or a riot or something along those lines. And that requirement applies to everybody from the secretaries who worked in locked offices who never have any interaction with inmates whatsoever, to the therapists who, only interact with the inmates in controlled environments where they're on opposite sides of partitions or dividers or bars. It applies to everyone. And that may be a different scenario where, there might be a riot and the warden's office gets occupied and you need to be able to do this to defend yourself, which is very different than saying that everybody who works for the fire department needs to be able to climb a ladder and drag a hose up it. And you're the communications specialist who makes videos and posts on social media, and you don't ever go out on a fire. You would never need to climb a ladder or drag a hose. And so I think having that sort of factual assessment of what actually gets done, in addition to what the employer says has to be done, is the right way to approach this to prevent this from being sort of the escape hatch and remember too, this is for providing accommodations. This is not about giving somebody the right to sue over a termination, for example. This is the qualified individual with a disability question is what comes up when we're talking about providing accommodations in the workplace. So I'm proposing this to make sure that these employees with disabilities get that fair consideration for those accommodations. But I think that that's the right way to do it, is to look at the actual facts of what gets done, not just what gets written down on a piece of paper as might potentially needing to be done, or something that's listed to disqualify people with certain disabilities who we might just not want to have working here.
Okay, thanks.
Thank you, Tom, for that, I think, important question, and Ian for the thoughts on this. I'm going to ask a question, but before I do, I want to be very clear that I'm not going to ask anybody to vote on that definition today until we have clarified language or updated language that we will share out with everybody. We may end up doing this electronically because I'm not going to be putting you guys on the phone with me Christmas morning to try to get this done, or on Boxing Day. But I want to ask, do people have questions or concerns about the intent of Ian's proposed changes to the definition of qualified individual? Okay,
This is Lauren. I'd say I don't have any questions or concerns about the intent. I believe I understand it. That since I'm not a lawyer, I wouldn't feel comfortable voting on it. And I realize we're not going to vote on it today until I'd had a chance to look at that definition change and take it to some experts from the business community and see, can you see any problem with this? If that's fair. Thank you.
Yeah. Okay, so Andrew and Ian, I'm going to ask if I can work with the two of you, and Ian, you're going to be front line on this, on your suggested revisions. And my hope would be that we can turn something around to share out with the group early next week. I'd like to be able to go through this process next week and before everybody fully checks out for holidays. I want to come back up to the prior definition of disability. And again, on this one, I will not be asking for any kind of binding vote. And to be very clear, when we take a vote, we're voting to include it in our recommendations that then go to the full task force, that they will do with what they will. We are hoping and expecting they act on them, but we are not empowered to advance legislation. We're making the recommendation for them to consider. Understanding that we will revise based on discussions. And maybe before I ask this, Andrew, what is your current thinking on the inclusion or non-inclusion of the actual language and provision?
You know, as we sit here today, I'm frankly more in favor of striking that just so that we keep that, complete mirroring of federal law.
Okay. So again, without asking for a binding vote right now, I will ask for one next week. With the striking of the actual, which then brings us to full parallel with federal definitions, does anybody, as you sit here today, think you have fundamental concerns about examining that to make a vote and a recommendation next week? Okay, so Ian and Andrew, I'm going to work with you guys to clean up both of these definitions with the goal of circulating them. We'll get that to everybody as quickly as possible, so you have opportunity both to digest it, to review it, and to speak, as Lauren suggested, with some of the constituencies that you represent. But our intention then, if everybody becomes comfortable and we can move to a vote, I will set up a digital voting option next week, so I don't drag you onto another Zoom. Our intention then would be to offer these two definitions as two of this group's recommendations in our December 2023 report. Is everybody comfortable with that process and that direction that we're going? I'm seeing large nods. Tom, is that a question?
If we make this recommendation next week, can we also make it clear that as we are working through next year, if we have additional definitions, those can be looked at as well or added?
Absolutely. And to be very clear, my intention for the framework of our report is we will have recommendations we're prepared to make right now. We will name that we expect to be exploring additional definitions, including some of those downstream provisions, and it may be further in other pieces. But we will be naming two things. One, that we expect to make additional recommendations of definitions. We will list what some of those are that we are exploring, but we will be very specific to say and intentional to say that list is not exhaustive, that we reserve the right to examine all definitions. With that being the case, does everybody feel comfortable, again, with our intent is to move forward with a vote to see if we can include these two definitions for recommended repeal and replace? We will name that we are continuing to examine other definitions and expect to make recommendations in our 2024 report. Is there anybody that has concerns or objections to that approach right now to the report? Okay. And I do know that we've got people that are lawyers. We've got people that aren't. I know what it's like to be in that place. So feel free to reach out to Carrie or me in the coming week if you just want to talk through it and if you want to bounce things around or get clarity. And I know that Ian and Andrew will also be, continue to be great thought partners to everybody. But I don't want anybody to feel pressured into a decision, but I don't want us to hold off on it simply because not everybody is a lawyer. All right, so next thing I want to do is cover for our report. Again, this is what we currently expect to explore and address in 2024 with the big capital letters, all bold caveat that this list is not exhaustive or all-inclusive, but that the items we currently intend to pursue include the following: substantive exploration and recommendations around emotional distress, caps and modernizing of dollars, timelines for filing claims, standards for exhaustion, accountability measures, exploration of public accountability laws, for example, the incorporation of the 2010 DOJ standards, such as what Texas did, the burdens for enforcement and the role of approving entities like code enforcement and building departments. And outside of that, or in addition to that, throughout our work, we intend to examine the need to include simpler, plain language throughout. And we'll, as part of this, we'll include an examination of other state best practices. So I'm going to pause first and ask people to respond or react to the items I mentioned, does anybody have concerns about including those in what we intend to explore? And then I will separately ask, are there additional items? Does anybody have concerns about including those items as items we intend to explore? Then I'm going to get a little more formal on this. Would anybody object to those items being included in our 2023 report as items this subcommittee has identified for further exploration to make recommendations in 2024? Are there any objections? Okay, seeing and hearing none, we will incorporate those. My next question for open conversation, with the understanding that the table remains open, this language is going to say we're going to examine these and others that are identified in our work. Does anybody want to identify others at this point to include in our report? Mr. Montoya, please.
Thank you. This is Andrew. One other thing I would like to see included, and we haven't had a whole lot of discussion about it, but is the potential for off-duty usage of medical marijuana for individuals. Again, there was a bad Supreme Court, Supreme Court decision in Colorado that kind of put Colorado behind a lot of the other states that have since incorporated medical marijuana, that says that people can't use medical marijuana off duty because it is federally illegal. A lot of other states have gone the other way and allowed for off duty usage. And frankly, we'd like to see Colorado at least brought up to that standard that other states have set, if not, leading the way in allowing for off duty usage.
For clarification, Andrew, are you proposing that this group may offer recommendations regarding the use of THC or cannabis by individuals with a disability or by all Coloradans?
By individuals with a disability.
Thank you.
Mm-hmm.
Thoughts and reactions? Tom?
Well, actually, I'll do two things. One, I agree with Andrew on that, but also, had we discussed, and maybe I missed it, also talking about timeframes or dollars that need to be spent by different entities to come up to meeting the ADA standards. I hope I'm phrasing that to where it makes sense.
I don't have that as a note, but I think we can open that to discussion. So for clarity, you're saying, do we want to suggest, make recommendations or explore making recommendations for minimum or maximum amounts an individual or a business would have to spend to be in compliance, and a timeline for doing so?
Correct.
Reactions from the group?
Go ahead, Andrew, and then I have a
Let me
question.
get Lauren in first. Lauren, go ahead.
No, I might need that to be explained one more time. I'm not sure I understand.
Yeah, and let me try it, and then Tom and Andrew, I'll ask you to make my answer correct if it's off. But I believe, Lauren, the suggestion is not that we're going to make a recommendation on it, but that we're going to include in what we explore whether we should make a recommendation to include in state law specific provisions that say those not in compliance with the ADA would have a certain maximum time to come into compliance and would be expected to spend a minimum or maximum of certain dollars to come into that compliance. Tom, do you want to go first, and then I'll ask Andrew to weigh in as well?
I think you covered it correctly. And it could be a sliding scale depending on how egregious the violation is or was, if that's possible.
Andrew, as one of our two lawyers, and then Ian, your thoughts on these provisions and the current state of things on it. And again, I want to be clear, what we are naming is issues to explore, not issues that we are currently going to make a recommendation on.
Okay, so this is Andrew. I've got a couple of thoughts with respect to that. First is that the ADA itself has called for transition plans. So, beginning back in 1990 when the ADA was enacted, states and local governments were supposed to come up with transition plans to bring themselves into compliance. I I don't think I would be in favor of kind of restarting that clock and, allowing for a new period of time, because we're 30 plus years past when those transition plans should have been in effect and frankly accomplished. But I do think it's worth further discussion. To that end, I don't know that I would recommend including it in our January report or December report, whatever that is. But I do, I do think that would be something we could discuss further. Yeah, I'll leave it there. Thank you.
And that's right. And I just want to be clear that what we're talking about now is not any items that we're trying to litigate on screen right now, but rather to say this is something we may consider in our future discussions. And no issue that we say we're going to consider are we obligated to make a recommendation. We're just reporting out to the task force on what we will be exploring. Ian.
Thanks, Barrick. Ian Kalmanowitz. I think it's an issue worth discussing. I just would add a concern I have about putting things into the law with respect to dollars. As we've had some discussions here about caps, and the caps that we're dealing with that exist today are 30 plus years old, and so I hesitate to write anything into a statute that requires the spending of up to a certain amount or a minimum of a certain amount, because of the simple things that I could think about is just like over the last 5 years the wild increase in the cost of building supplies, for example, and how would that impact necessarily somebody's obligation to retrofit bathrooms in a I don't know, a gym, for example, or so but I do think this is a discussion that's worth having. I feel like one of the places where a lot of this can be addressed is what we've been talking about with the building codes, and putting more of an onus on the local building authorities, et cetera, in terms of what guidance they're giving to people who are doing construction, renovation, et cetera. And then with respect to the medical marijuana issue that Andrew raised, I do think that's an important one, and I wholly support that idea. And I think one of the things that we all ought to do as we talk about that is again, just be clear up front that it is medical marijuana for off-duty use only. So not recreational marijuana, not on-duty use. Our state constitutional amendment that authorized medical marijuana specifically says that an employer does not need to accommodate the on-duty use of medical marijuana. So I think we should just be clear that is not a guardrail we're looking to get anywhere near in discussing the idea that an off-duty use shouldn't be something that could disqualify you from continued employment.
Thank you, Ian. So I'm going to discuss each of these. Lauren, did you have something to ask?
Yeah, I wanted to add about the MJ. I mean, the problem that the business community is going to have is until there's testing to determine whether or not somebody is under the influence, it really is problematic for businesses, whether you're conducting surgery on someone or operating heavy equipment, or if you have contracts with the federal government that require that. There's just no way to test it now. And that's where the business community keeps pushing back. So,
Lauren, I appreciate you raising that. And I do want to be clear, and that probably highlights, if we move this forward, one of the conversation we would need to be having. But what I'd like to do is, rather than even talking about what all the aspects of the discussion may be, just check with everybody for whether we want to include these in our reports. So my first question is going to be, with an understanding this does not in any way imply we will make a recommendation, much less a recommendation one way or another. Does anybody object to including in the list of topics we have identified as worthy of exploring and soliciting diverse perspectives and expertise on the use of cannabis or marijuana by individuals with a disability during off-hours times? Does anybody object to us including that as an item we will explore and seek opinions on.
This is Cindy. I don't have an objection. I just want to add a comment. I think the points that we've raised are really good. I just feel like there's probably going to be additional things that we haven't included. Obviously, we're not getting into the weeds in this report. So I would just ask that maybe when you're working with the two attorneys and putting out these definitions next week, that we take a look at this overall report and build in an elastic clause, if you will, but something that gives us kind of that robust ability to consider other things as appropriate, so that we have that ability to look at other things as they come up that we say, oh wow, we didn't think of this, but this is really important.
Absolutely. Let me check on our other issue. Again, no commitment that we will make a recommendation, much less that it will go any direction or another. But for the inclusion of this item as something we will explore and solicit information and perspectives on, the timelines and costs to come into compliance with the ADA. Within our report, a note of the concern about putting today dollar values onto something into statute that may become outdated. Does anybody object to us including as an item for exploration by this subcommittee? Okay, then we will add those two, and that makes our list of items. Ian, please.
Thanks, Barrick. I'm sorry to just jump in with this, but I had one other item, and I believe I've discussed this at least once in a prior meeting, but one of the things I would propose that we also explore and talk about some more is putting something on paper about the interactive process that is required in determining what a reasonable accommodation might be. So the law has developed in a way, and it's all judicially created, that and I'll use just the employment context, but this does apply, I think, in the educational context as well. When an employer is aware of an employee's need for a reasonable accommodation, or an employee requests a reasonable accommodation, the two sides are supposed to engage in what the courts have called an informal interactive process, which is a back and forth discussion about what potential accommodations might be available, what information the employer might need from the employee. I would like, this is an area where we see a lot of problems for both employers and employees, in terms of employers not knowing what they're allowed to ask for, or employees thinking that employers aren't allowed to ask for things like medical information, for example. Also, we see a lot of employers who say something to the effect of like, well, the only accommodation we can give you is unpaid leave until you're better. That's not really an accommodation. I think I gave the example of a case that I'm handling right now for a woman who requested a reasonable accommodation, and the employer's response was to say, well, we'll move you from this manager position to an administrative clerk position and cut your hours from full-time to 8 hours a week. That's not a reasonable accommodation. I would like to, I think it's something that this is an area where I feel like we could, as a state, provide that paradigm that Andrew was talking about earlier, that leading edge, national model for other states in terms of how we address this interactive process issue. And so I'd want to flag that as something that we include, and really only as, it can be just a bullet point for this December report, but it's something that we really kind of dive into in more depth next year.
So for sake of keeping this as broad as possible to give you guys the ability to explore it, Ian, is your proposal that we include something about the overall process and rights relating to reasonable accommodations as our area of inquiry?
Yeah, I think that's a fair way of describing it.
Questions, concerns? Does anybody have an objection to what would be our third edition? And I'll go through the full list, but this edition would be an exploration of the process and rights for determining reasonable accommodations. Any objections to that? Okay, so I'm going to go back through and just wrap up where I believe we are and check if anybody has any concerns or different understandings. I know we're down to 5 minutes. Our current intention is we have 2 definitions that we will offer as recommendation changes to repeal and replace the definitions of disability and qualified individual with a disability based on the conversations and what will be some new drafts that we will circulate early next week. Our identified areas of substantive exploration going forward will include, but not be limited to, emotional distress, caps and modernizing of dollars, referencing the 1991 dollars in statute, timelines for filing claims, standards for exhaustion, accountability measures, public accommodation laws, including incorporation of 2010 DOJ standards, burdens for enforcement and the role of approving and oversight entities. Our new 3 would be the off-duty usage of marijuana by individuals with a disability, timelines and costs to come into compliance with the ADA, with the note of ensuring we don't put about putting today dollar values into statute. And our last one, the process and rights for determining reasonable accommodations. The other item that would be in our report is a clear note that we will be exploring all opportunities to use simple, plain language wherever possible, and that part of our process will be examining other state best practices. Do I have any concerns, or let me get formal actually, do we have any objections to those being the items included in our report? Okay, and I am reminded that to maintain compliance with open records requirements or open meeting requirements, what we will most likely need to do is have your informal vote registered electronically, and then we will need to convene briefly as a formal meeting with public notice to cast the formal votes approving the items and voting on the items we'll include in the report. So that will be the process. We will work with you to make that as easy to fit into your schedules and as brief as possible, but I want to make sure that we do comply with all of those requirements. Does anybody have any concerns about the direction we're going with the report, the preparation of new drafts for everybody to review, or the process we'll go through as a subcommittee to approve and advance those recommendations? Okay, then my next step will be Ian and Andrew to follow up with you first of the week. I appreciate you guys, and hopefully this is a minimal lift. I really appreciate everybody. I know we asked you for 1 or 2 meetings between November and December. I put you into a third, and I'm asking you for a 4th brief conversation to approve these, but really appreciate everybody's time and strategic thinking on this. Does anybody have any closing thoughts or last thoughts or questions for the group? Okay, seeing and hearing none, I hope everybody has a great weekend. We will follow up by email early next week and appreciate your time. Thanks all.